Welcome back to the OMB Law Board. I'm Simon Bennett. Today I've got Harley Wilkinson from our estates team. Harley, welcome back to the podcast.
Good to be back. Thanks for having me, Simon.
So Harley, with estates, this is like hotly contested area. It's often very acrimonious, but I'm talking about contested estates.
Yes, contested estates. The lawyers love these.
Do they? Let's start from the beginning. What is a contested estate?
So a contested estate is really where a person is contesting the terms of a will. And that's going to be because they either haven't been left any provision under a will, or they haven't been left adequate provision for what the legislation says is the proper maintenance and support of that person.
Okay, so tell me, I've left a will and I've decided how I want to leave my estate and my assets.
Yes.
But you're now telling me that people can contest how I leave my assets. So who can contest it?
So it's not just anyone that can contest a will. The legislation, and when I say the legislation, it's the Succession Act in Queensland. The Succession Act says that eligible persons can contest a will. Eligible persons are going to include generally a spouse, a child or a stepchild, or some other sort of dependent person who was dependent on the deceased before they passed away.
So it's qualified.
Yeah, that's right. Yeah. So not just anyone. You can't have, siblings, aunts, uncles, or friends, that sort of thing, contesting wills. Your spouse will be the husband or wife of a deceased, as well as a de facto spouse. And children are going to be biological children, stepchildren, or adopted children.
Okay. So I don't want my will contested. Give me your top tips for how I prevent that happening.
Look, it's not always possible to do that. You can't take away someone's right to contest a will if they are an eligible person. The steps that you can take to try and reduce that risk is going to be turning your mind towards, well, to what extent is this person dependent on me for financial support and provision? If it's significant, or if there's even a little bit, there might be an expectation from that on behalf of that person that they're going to receive a share of your estate. So it's always very risky when you've got eligible persons who are excluded from a will. And in the event they aren't left any provision whatsoever, there's a very high risk that they will contest the will to try and get a bit more out of it.
Can I deal with that situation by explaining in some way why I haven't made a provision for them, that maybe I've made ample provision for them during my lifetime? I may have assisted them buying properties, etc. Is there a way that I can reduce that risk?
Absolutely. A lot of the time, will makers might also prepare a letter of wishes or a statement of wishes or something along those lines or of that description that is read in conjunction with the will and really sets out and provides reasons about why the will is made why the will is made the way that it is, and why a certain person is either excluded from the will or not left with very much provision. And it could be for any number of reasons. And like you said before, because certain gifts may have been made during the will maker's lifetime, or it could even be just because there's distance in that relationship and there's been estrangement over a number of years, and that particular will maker wants children or other persons to receive a benefit from their estate over someone with whom they've had no contact for many, many years.
The other thing that really worries me, from a contested estate perspective, is the costs. There's a lot of costs involved.
Yes.
How do they get dealt with?
Costs are definitely a big issue, and it is not cheap to contest an estate. The starting position is that a person wanting to contest the estate will pay their own costs, but the way in which that actually turns out depends on who wins and who loses, because costs usually follow the event. But that decision is ultimately up to the court. It's within the jurisdiction of the court to make decisions about costs orders. But if you have an eligible person who contests a will, they are successful in their claim, a court makes an order for further and better provision, it's usual that most or all of their costs will be paid out of the estate.
Is it possible that I leave a substantial sum to a beneficiary under a will and they can still contest it and ask for more?
Technically, yes, they can. And again, it just comes back to the fact that they're an eligible person. So they're eligible to apply to the court and seek further and better provision. But the likelihood of success in receiving further and better provision depends on a really broad range of factors that a court needs to consider. One of those being what measure of provision is already left for them under the will, and is that provision adequate and adequate for their proper maintenance and support. And to answer that question, courts have to look quite far at that person's circumstances, as well as the circumstances of the estate, the beneficiaries that are going to be affected by any order the court might make, in order to determine what further provision is actually going to be necessary, or what's correct in that particular situation.
So it sounds very much case-by-case driven?
Very much case-by-case driven, that's right. So every single matter is different, or every single estate is different, and the circumstances of every applicant are different.
So there's no assumption of equality, if you like, where let's say there's 3 surviving children of the deceased, that they should all get an equal share?
No, that's not true.
Okay.
No. So it's not as simple as there's 3 children under a will, or 3 children of a deceased, 2 of whom are named as beneficiaries in the will where they receive equal shares, and you've got 1 who's excluded. That excluded child does not by default get a 1/3 share of the estate if they contest it. They could potentially get half of the estate. They might only get 10%. They might get nothing. It all comes back to what their provision is, if any, their personal, their financial circumstances. Are they working? Have they saved for retirement? Do they own a home? Do they have dependents? And aside from all of that, what the estate's position is, what their relationship was with the deceased. There's a whole range of different things that come into consideration in order for that calculation to be made about what is adequate provision. So even though, looking at it from the perspective that you might say is fair, or what most people might say is fair, isn't just a equal share, because everyone's idea of what's fair is different.
So our listeners and our viewers want to know, I want to make the most binding version of will that's uncontestable as possible. How can you and the OMB Estates team help me?
We can help by, I think, having a really holistic look at all of the different things that are going to be coming in and affecting your estate plan. I just want to impress upon everyone, it's really, really difficult to, if not impossible, to have an ironclad, risk-free will. But there are a lot of different things that we can look at, and there are a lot of different things that we can do to reduce or mitigate the risks that are involved in putting that estate plan together. And I just want to mention, one thing that has come up recently, and I think one thing that exists in other jurisdictions, is a sort of no contest clause in wills that basically says, or the idea of it being that if beneficiary A decides to contest my will, then they'll miss out or forfeit what is left to them under the will. You might have people who put that in the wills here, but it has no effect. It's not binding.
Okay.
So that sort of thing doesn't work.
And if any of our listeners or viewers have, felt that they haven't been adequately provided for under a will, where they are financially dependent on someone, you can help them?
Absolutely, yes. Yeah. So we act for both applicants who are seeking to make applications for further and better provision from an estate. We also act for executors who are going to be tasked with defending against those applications, as well as beneficiaries who might sometimes just be on the sidelines and need a bit of help or advice along the way.
Fantastic. Well, thanks for coming in today, Harley. That was really informative and interesting.
You're very welcome. Thanks for having me.
So there you have it. Absolutely hotly contested, very emotional issue, often dealing with family disputes. And our estates team here at OMB are more than happy to help any of our listeners or viewers with any inquiries they may have in respect of estates, estate planning, or indeed contested estates.